Hey there, Tony DeWitt here. I'm a retired Missouri attorney now living my best life on a beach in Florida. I offer content and commentary on current events in the law as well as some general legal topics, but I do not dispense legal advice by video. With that understanding out of the way, here's what we're discussing today. There's a case going on right now in Panama City, Florida, involving a Navy veteran who was allegedly defamed by CNN. Essentially, CNN said he was a black market purveyor of extractions from Afghanistan, somebody who profiteered on people who were desperate to get out of Afghanistan after the Taliban took over. Although CNN will later offer an apology, that doesn't cut it. The judge in this case held that the apology was insufficient. The case was filed, it's been prosecuted, and it's finally processed itself into a trial. But instead of doing the honorable thing here and admitting that they have, in fact, defamed this individual, which is certainly what it looks like to me, in my opinion, CNN hired some of the worst in terms of defense attorneys, and they are putting on a scorched earth defense in this case. Now, I have to say that in every case, there are good things and bad things that happen. But in this case, I have been really kind of shocked at the ineptitude of the defense, at least as far as cross-examination goes. And I've also been impressed with the way the plaintiff in this case has stood up under cross-examination, because you usually don't see that happen. Before we get into that, though, let's take a look generally at defamation law. Defamation is essentially a false statement presented as fact that injures a party's reputation. Now, libel is when you do that through a written word, for example, a newspaper, and slander is through a spoken word, but the fact is they both fall under the tort of defamation. Now, like any kind of tort, there are elements of a defamation claim, the things you have to prove in order to prevail. And they vary from state to state, but generally it includes, first of all, a false statement. The statement in question has to be false, and essentially they said he was profiteering. That's because truth is a defense to defamation. Claiming that somebody committed a crime they did not commit, well, that is an example of a false statement. Joe is a thief. Well, again, that is a false statement that could get you sued if, in fact, Joe is not a thief. In Philadelphia Newspapers versus Hepps, a 1986 Supreme Court case, the Supreme Court emphasized the necessity of proving falsity in defamation claims concerning matters of public concern. The second element, publication. The false statement has to be communicated to at least one person other than the plaintiff. So, if you tell Joe, you're a thief, that may be a false allegation, but it hasn't been published to anyone. You might want to look at a case called Snyder versus Phelps, which involved the publication of statements on public property addressing the scope of publication and First Amendment protections. The third element is injury. The statement has to cause harm to the plaintiff's reputation, but that harm alone is not usually enough. It has to lead to other damages, like a loss of business, emotional distress, that sort of thing. So, as in this case, where a business loses customers due to statements that are false about its actions or its reputation, that is the kind of loss that comes up in a defamation case. There's a case called Gertz versus Robert Welch. It's a 1974 case where the court discussed the requirement for showing actual injury in defamation cases involving private individuals. Next, there is fault, and fault might actually be better stated as knowledge. You either knew or should have known that the statement was false, and you went on ahead and you published it with some kind of either negligence or reckless disregard for the truth or falsity of the statement. Now, there are different requirements for different people. You may recall in the Amber Heard, Johnny Depp case, because Johnny Depp was a public figure, they had to prove actual malice, knowledge of the falsity, and reckless disregard for the truth, and they proved that. With private individuals, however, somebody who is not in the public eye, you have to show at the very least negligence. The Sentinel case is New York Times Company versus Sullivan, a 1964 case that established this actual malice standard for public officials. And again, the statement has to be a statement of fact. It can't be a statement of opinion. Saying John is a thief is a statement of fact. Saying, I think John is dishonest is a different statement. It's a statement of opinion. And even when you might couch something as a fact, it may sound like a fact. If the context around it indicates that someone is expressing an opinion, that too may not fly under defamation. The case there is Milkovich versus Lorraine Journal Company, where the court clarified the distinction between fact and opinion in defamation cases. Now, there are three defenses to defamation. We've already dealt with two of them, truth and opinion. The third is privilege. Now, that's not privilege like attorney-client privilege or the priest-penitent privilege. It's a different context. In the context of a defamation claim, the concept of privilege refers to certain situations where a person is protected from liability for making statements that would otherwise be considered defamatory. Privilege is a legal defense that can be either absolute or qualified, depending on the context in which the statement was made and who made it. Here's the breakdown. Absolute privilege. That provides complete immunity from defamation claims regardless of the intent or truthfulness of the statement. The privilege is typically applied in contexts where open communication is essential. For example, a courtroom. Judicial proceedings are definitely protected by absolute privilege. Statements made during those proceedings are protected to encourage witnesses and attorneys to speak freely without fear of litigation. Legislative proceedings, statements from your legislators and your congresspeople, those are privileged. And as I mentioned earlier, executive communications, certain communications by government officials within the scope of their duties are protected to ensure that those officials can perform their functions without fear of defamation lawsuits. Qualified privilege is a little different. Qualified privilege offers protection for statements made in good faith under circumstances where there is a public or private interest in allowing the communication. However, this privilege can be lost if the statement is made with malice or if it exceeds the bounds of the privilege. For example, when an employer gives an employment reference, that can be, in some cases, defamation. But when they are providing honest, factual information, and it is shared in the spirit of honesty and without malice, usually a qualified privilege will prevail. Public interest communications, statements made to warn others about potential harm, like that guy that moved in down the street, he's a pedophile because I saw his name on the sex offender registry, and it turns out to be a different John Doe than the person that they think it is. That again may very well be a public interest privilege that would apply. Media reporting. In some jurisdictions, journalists have this qualified privilege, which in the 21st century, I really don't think they ought to have, but that's not up to me. If you watch this trial, you can tell that the lawyers absolutely hate each other. That's not supposed to be the way it is. You're supposed to get along. That makes it easier on the judge, but some lawyers are just incapable of that. The other guy is Hitler, and you have to bury him. It makes for a very painful trial on both sides, and certainly for the judge, and in most cases for the jury. They wonder what these two people are up there doing, acting like school children. In this case, the lawyers for CNN pulled out a document that they had never provided to the plaintiff, and it drew an objection. Let's watch.
So, Mr. Young, I want to focus on your alleged economic damages, okay? So I'm trying to understand your argument about economic damages. So I think you testified yesterday, but tell me if I got it wrong, that since the CNN broadcast, you've had no work. Is that right?
Correct.
And would it be your contention that since the CNN broadcast, no one will deal with you?
Yes.
fair to say that your testimony is that that you're a pariah,
Yes.
and you allege that that's because of CNN?
Yes.
And so just to make sure I understand it completely, your assertion is that since the CNN publications on November 11th, no one will work with you.
That's correct.
Okay. Sir, isn't it true that in December of 2021, you signed a consulting agreement with a government contractor called Helios Global?
Yes.
Okay. And what I'd like to do, I'm handing you what's been marked as Defense Exhibit 589. Mr. Domestic, can you show those? Yeah. Oh, Your Honor, may I approach?
You may.
May we approach for a minute?
Your Honor, pending questions. I would like to ask them. I don't think there's a question that's pending. I don't think that there's a reason for an objection until I ask a question.
It's documents on the exhibit list.
Oh.
It's for impeachment.
What do you mean for impeachment? There's nothing to impeach.
So the plaintiff objected, and the court went back and studied the matter and allowed the defense to use the document. I believe it was error, but what I believe probably doesn't matter. So with the ability to use the document, the lawyer goes into cross-examining him on this document. But what's about to happen here is going to demonstrate to the jury that he may very well just be an idiot. But watch the questioning.
So, Mr. Young, I think the last question I asked you was, sir, isn't it true that in December of 2021, you signed a consulting agreement with a government contractor called Helios Global? And your answer was yes, correct?
Yes.
Do you have Defense Exhibit 589 in front of you?
I do.
And that is your signed consulting agreement with Helios Global, correct?
Correct.
Your Honor, I move for the admission of DX 589.
Your Honor, based on our discussions earlier, you know my position on this. We object, but
All right.
I understand the court's order.
Over your objection, I'll admit Defense 589.
Okay, Mr. Domestic, can you publish? So, first of all, let's go down to the, can you go up to the bottom? So, Mr. Young, on the right, that's Helios Global, Ian Conway, correct?
Correct.
And Helios Global is a government contractor?
They are.
On the right, on the left, consultant signature, that's your signature, correct?
Yes, it is.
And that's the address, Nemix's address. I think that was your mother's
My mom's home address.
home address. And you signed this electronically on 8th of December 2021, correct?
No, I think this was printed and signed. I mean, it's my wet signature.
Okay. The date of this contract is December 8th of 2021, correct?
Yes.
Okay. You would agree that December 8th of 2021 is about a month after the CNN publications, correct?
Yes.
Now, the point the defense was making here was that the case is about lost business opportunities, and Mr. Young signed this consulting agreement after CNN published his story. So there must be no damages. He keeps referring to it as a contract. Now, the CNN lawyers are saying there's no case here, there's no damages because this contract exists, but that isn't the end of the story. Because after cross-examination, what comes? Redirect. And that's what happens. What exactly was it that Mr. Young signed in terms of a contract?
It says Consultant Security Agreements Act. Do you see that?
I do.
Now, I know Mr. Axelrod did give you a chance to explain it, so I would like you to. Please go ahead.
Okay. So, with somebody who doesn't understand anything about security clearances or how the process works, you have to have a little bit of background information. Once you leave government service, you can't personally hold a clearance by yourself. It has to be through a company that has an agreement with the United States government. They are the ones that have to sponsor the clearance. The clearance is issued by the U.S. government. The renewal process, when you have to go through a reinvestigation, that happens by the U.S. government. This is just a company, like any defense contractor, that has the contracts with the U.S. government and they hold the clearance for the individual. Typically, they have people like me who are basically in the stable that they can.
Foundation.
Rule.
People like me who have various backgrounds that are not in the government anymore, that they need to be able to tap into on short notice. And the way that they do that is they hold the clearance for you. In my case, it's through this company, Helios Globos. But part of the process and what you're seeing here is every year you have to sign this administrative document with whoever holds your clearance. In this case, it's Helios. It's not an agreement to do work for them. You don't see any numbers here. You don't see any project here. It's just an administrative function that they have to do every year to keep your clearance for you. So very grateful to Ian. If he's watching, I hope he knows that. But I haven't ever had any work from Ian. I've produced 7 years of my bank records, my own personal, and Nemex is my company. Never once, CNN knows this, there's no transfers from Helios Global.
So all that drama, all of that drama with pulling out a document that had been hidden for the sole purpose of saying he was getting money from Helios Global when he hasn't gotten a penny from Helios Global. The plaintiff turned over bank records. There's no payments from Helios. There's no there in this line of questioning. And the jury and the judge is dumber and older for having had to sit through that. And the judge is likely ticked off that he had to rule on this evidentiary issue when there was absolutely no relevance to that document. You see this sometimes in almost all kinds of cases. The lawyer will find some small thread that he thinks he can pull, and he'll make as big a deal about it as he can in the hopes that the plaintiff isn't prepared for it. And of course, in this case, the plaintiff said, look, we've not seen this document. We don't know what it is. We haven't talked to our client. But when they talked to the client, he got to stand up on the stand and explain what that contract or what that document really was. It wasn't a document he was going to get paid for. It was just a document to make sure that he had a security clearance if that company ever wanted to use him. It is frequently the case that lawyers score points only to later see them pulled off the board by the other side. But what you don't want to do is bring up an issue that you know doesn't help you with the aha kind of language, and then when it gets sorted out, you look like you didn't know what you were doing. According to people who have been watching the trial, it appears that the jury has kind of tuned out the cross-examination of the plaintiff. They listened to the direct examination fairly carefully, but they kind of tuned out the cross-examination, I think principally because of the manner and mechanisms of this defense counsel. He doesn't appear to be prepared. There are long pauses during his examination where he searches for documents and pulls them out. And I think that if you don't have everything ready to go and pre-planned, it really makes for a bumbling appearance. Now, sometimes that can work in a Columbo kind of thing, but this guy's not Columbo. Now, again, I'm just sharing with you my opinions here about how this has been handled. This guy may be the best lawyer since Thurgood Marshall, but it doesn't come off that way in terms of how he's handled it so far. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.